I'm going to be talking today about the Northwest Passage. Of course, we heard quite a bit about the Northern Sea Route earlier today, and although the Northwest Passage in some ways is certainly not as pressing as a navigational issue, there are all kinds of thorny problems associated with it. So I want to use my brief time partly to just introduce some of the issues, but also to bring up a potential way through the Northwest Passage that actually has received very little attention. I also just want to note that although I am from Durham University, I'm actually not going to be talking about the Durham polar map that, is often a matter of discussion here. Okay, so briefly, just as an introduction to the Northwest Passage, although it's not technically a bilateral Canadian-U.S. Dispute, it's often posed that way, and certainly both countries often refer to the other one as the one having the main other opinion. So just to quickly review the Canadian position, it is that the waters of the Northwest Passage are Canada's historic internal waters, and a range of legal reasonings have been put for this, everything from the history of Inuit use, and effectively there had been Inuit sovereignty, then transferred to Canadian sovereignty, the fact that there's been little historic use of the passage as an international strait, various arguments pointing to the special nature of ice and the ways in which, again, in particular, Inuit have used ice and the way in which ice kind of bridges a land-water divide, and then how this has all been affirmed by Canada's declaration of strait baselines in 1985 around the Arctic archipelago, which we've already heard about. And of course, this is all taking place as well within a political context regarding the important role of Arctic land and water in Canada's national identity as part of its national patrimony, et cetera. And with recognition of the waters as Canada's internal waters, effectively Canada would have full control of the passage. The US position, in turn, is that the Northwest Passage is an international strait. Part of the legal reasoning for this is simply that it meets the physical criteria of an international strait as defined in UNCLOS. And to the extent that there are use criteria that have emerged through case law, the US position is that this use criteria can refer to potential use as well as historic and current use, and therefore the fact that there is potential, especially with climate change, brings that up as well. The driving political context behind this is generally recognized not so much as fear that Canada would stop US cargo ships from navigating the passage, but more the precedent that this would set for other international straits. And given the importance of navigation through international straits to US policy generally, and more broadly maritime mobility, that this could whittle away at that freedom of navigation. If indeed the passage were recognized as an international strait, the rights that would accrue to Canada would be considerably more limited. Under UNCLOS's transit passage regime, a coastal state may engage specifically in non-discriminatory application of international regulations on 4 defined areas: fisheries, navigation, smuggling, and pollution. And in addition to the delineation of those 4 areas and the restriction to international regulations, there's also the stipulation that transit passage cannot in any way be impeded. Additionally, there's debate over whether the specific provisions given under Article 234, which we also heard about earlier, the extra rights that a coastal state has in ice-covered waters for environmental protections, there are debates about whether those would apply to an international strait or not. The UN Convention on the Law of the Sea is a bit ambiguous on that point. So basically what I have here is just pretty much graphing out what I just said, the 2 main options that we always hear out there with reference to the Northwest Passage. What I want to do in the rest of my time here is bring up another option that you actually very rarely see in discussions, in part because it's so often framed in the US position versus the Canadian position, and that is, what if the passage is considered neither an international strait nor internal waters? In that case, you fall back to the zonation that we've already heard about in the Law of the Sea, in which case waters that are more than 12 nautical miles from the coast are exclusive economic zone, and waters that are less than 12 nautical miles from the coast are territorial sea. Now, in fact, in a body of water that has points that are fewer than 24 nautical miles wide, by definition, you're always at some point then within 12 nautical miles of a coast. So effectively, you have these choke points that would turn the waterway, the passage, into territorial sea, at least for through transit purposes. So you would have, in the exclusive economic zones, the high seas navigational freedoms, but in these areas fewer than 12 nautical miles from the coast, the territorial sea rights of innocent passage, which ultimately would mean that over the course of the passage, you would have this innocent passage regime, which would grant to coastal states much broader rights than under the transit passage regime, rights to apply non-discriminatory regulations to innocent vessels and to ban transit by vessels deemed non-innocent. So how would we get there? I mean, that already begins to sound like a compromise down the middle. One way we could get there, which I'm not going to talk about, is actually for Canada's position to be recognized as internal waters, but as non-historical internal waters, and I won't get into the technicalities of that. But I think it's worthwhile to finish up, though, by looking at what each state would gain and lose from this compromise to begin to maybe, as it were, thread a middle route through the Northwest Passage. If we turn to Canada, obviously Canada would lose legally calling these waters its internal waters. However, I would say that given the rights that already accrue to coastal states in their territorial sea, which are significant, and then you add to that the Article 234 rights to waters that are ice-covered most of the year, and then add to that as well the fact that most travel in the Northwest Passage will be destination-based, which means you can control through port regulations. Effectively, Canada gets almost all of the rights that it would have as internal waters, with really the only significant loss being the ability to apply environmental regulations to ships with sovereign immunity. You can say, well, that's fine legally, but how would you get there politically, given the importance of the Northwest Passage in Canadian identity and domestic political rhetoric and the like? But effectively, Canada would get out of this, the US recognizing that these are Canadian territorial waters, which arguably is a greater political gain than maintaining a contested internal waters claim. They could either effectively, Canada could undo its straight baselines legislation or keep the straight baselines but acknowledge they were non-historic waters within them, which again would get to the same solution. And then a final real benefit for Canada is that it would crystallize the status of the waters of the passage as something other than international strait before ice melt continues and before uses increase. And that's a danger that several Canadian jurists have brought out for the Canadian position. From the US side, obviously the US would lose the opportunity to cite the Northwest Passage as an international strait with a transit passage regime. But on the other hand, there also wouldn't be any precedent for weakening the international strait regime. Effectively, if the Northwest Passage is just taken out of the international strait category, and if that's really the US's main concern, then they've basically insulated the Northwest Passage from having any diminishing effect on that. It also creates an incentive then for Canada to invest in infrastructure and security in the passage, which would be to the US's benefit as a likely user of the route. And really the only significant loss for the US would be the ability to sail submerged submarines without notification. And in terms of the politics in the US, I think that would be incredibly simple because nobody in the US really cares about the Northwest Passage except, certain naval planners and the like, but certainly in terms of popular awareness, it's not out there. So really what we see are these two remaining issues that emerge. And what's interesting about them is they're actually relatively parallel. They're both about very specific uses of certain ships with sovereign immunity. It's exactly, without a whole lot of knock-on effect, it's exactly the kind of thing that negotiations, I think, could happen on. And of course, I leave that to the diplomats in the room to figure out how to do. So thank you.